Hello and welcome once again, this time to Module 7. I'll start with a discussion about witness competence. Under both FRE 104 and Florida Rule 104, it is the duty of the trial judge to determine whether a witness is competent to testify if the issues raised by any of the parties. This includes expert testimony under FRE 702, which will be discussed in great detail in both the Module 14 readings and the Module 14 lecture. Most often this issue is generated when a witness is a young child or an adult that's mentally handicapped. But there's a significant competency question that occurs in virtually every trial of some sort whenever non-expert evidence and testimony is presented. The question can be described very simply. Is the witness going to testify based upon their personal knowledge of the subject of their evidence? That is, from what they actually experienced through their own five senses. Thus, other than when testifying as an expert witness, lack of first-hand knowledge usually will disqualify a witness from testifying. FRE 601 deals with competency to testify in general. Every person is competent to be a witness unless these rules provide otherwise. But in a civil case, state law governs the witness's competency regarding a claim or defense for which state law supplies the rule of decision. And essentially, that second paragraph deals with diversity of citizenship cases that are tried in the federal court but are based upon state law, that is, state substantive law. The federal procedural law, including the rules of evidence, applies otherwise. Notes of the Advisory Committee on Rules states this general ground clearing eliminates all grounds of incompetency not specifically recognized in the succeeding rules of this article. And this article refers to the entire set of federal rules of evidence. Included among the grounds thus abolished are religious belief, conviction of crime, and connection with the litigation as a party or interested person, or spouse of a party or interested person. With certain limited exceptions, American jurisdictions generally have ceased to recognize these grounds as disqualifying the witness on grounds of competency. No mental or moral qualifications for testifying as a witness are specified. Standards of mental capacity have proved elusive in actual application. A leading commentator observes that few witnesses are disqualified on that ground, and that's Wehoffen in his article at George Washington Law Review. Discretion is regularly exercised in favor of allowing the testimony. A witness wholly without capacity is difficult to imagine. The question is one particularly suited to the jury as one of weight and credibility, subject to judicial authority to review the sufficiency of the evidence. And that's as Wigmore concludes the issue. Standards of moral qualification in practice consist essentially of evaluating a person's truthfulness in terms of his own answers about it. Their principal utility is in affording an opportunity on voir dire examination to impress upon the witness his moral duty. This result may, however, be accomplished more directly and without haggling in terms of legal standards by the manner of administering the oath or affirmation under Rule 603. And the oath or affirmation, of course, among other things, requires the witness to state that they will testify to the truth and the whole truth and nothing but the truth. While we're on that topic, you may wonder why persons are asked to stand and hold their right hand up while they're taking this oath. If they don't do that, the oath is still valid. The purpose of making an individual stand and raise their right hand is to impress upon them and to signify to them that what they are about to do is extremely important and it's out of the ordinary, so that it requires special attention and focus. And more than anything else, yes, we really mean this. We expect you to tell the truth. FRE 603 provides that before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress that duty on the witness's conscience, as I have just said. Notes of Advisory Committee on Rules. The rule is designed to afford the flexibility required in dealing with religious adults, atheists, conscientious objectors, mental defectives, and children. Affirmation is simply a solemn undertaking to tell the truth. No special verbal formula is required. As is true generally, affirmation is recognized by federal law. Under federal statute, Article 1, the United States Code, Section 1, oath includes an affirmation. LexisNexis commentary on FRE 602 and Florida Statute Section 90.605, together, written by Messrs. Stephen A. Salzberg, Esquire, Daniel J. Capra, Esquire, and Michael M. Martin, Esquire, provides that, along with cross-examination, the requirement of an oath is designed to ensure that every witness gives accurate and honest testimony. In the Zizo case, the court stated that the idea behind the oath requirement is to preserve the integrity of the judicial process by awakening the witness's conscience and making the witness amenable to perjury prosecution if he fibs. Rule 603 states that a witness need not swear an oath, but may merely affirm that he or she will testify truthfully. The affirmation can be given in any form calculated to awaken the conscience of the witness and impress upon the witness the duty to tell the truth. By permitting affirmation as well as oath, many of the difficulties faced by certain members of some religious groups should be alleviated. Rule 603 does not require that the oath or affirmation be given in a specific form. Flexibility might well be required, for example, to accommodate beliefs and opinions protected by the First Amendment. And in that regard, Florida Statute Section 90.605 states that before testifying, each witness shall declare that he or she will testify truthfully by making an oath or affirmation in substantially the following form. Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth? The witness's answer shall be noted in the record. 2. In the court's discretion, a child may testify without taking the oath if the court determines the child understands the duty to tell the truth or the duty not to lie. The ability to articulate the difference between the truth and a lie is an essential element of a traditional test for determining the competency of a witness of tender years, and that's in Clendenning versus State. But of course, that, as a general rule, applies to adults also. Florida Statute 90.605 requires that each witness take the oath before testifying, except for young children. There is no exception for attorneys, even though they are officers of the court subject to disciplinary action for deceiving a judge by a false statement. And that's from Murphy versus State. The decision in Evans versus State, the Florida 2nd District Court of Appeals case, provides some additional guidance. An incompetent witness must be disqualified from testifying, and that's under 603(2). Palazzo versus State makes that comment. When the defense challenges the competency of a child witness to testify, the trial court must make specific factual findings relating to the child's competency. In Fuller versus State, the court said, before finding a child competent to testify, the trial court should consider 1, whether the child is capable of observing and recollecting facts. 2, whether the child is capable of narrating those facts to the court or to a jury. And 3, whether the child has a moral sense of obligation to tell the truth. In addition, while the trial court has the discretion to allow a child witness to testify without taking an oath, it may do so only if the court determines the child understands the duty to tell the truth or the duty not to lie, which language comes directly from 90.6052. Florida Evidence Manual, in speaking of Florida Rule 90.601, states that every witness is generally competent to testify, again restating the rule. A witness is presumed competent to testify until the contrary is established. A court's ruling on competency will be upheld absent an abuse of discretion, which is the standard for all rulings under Rule 104 as well. The federal rules of evidence state that where federal law controls the claim or defense, every person is considered to be competent to be a witness unless another rule provides otherwise. Under both Florida and federal law, the focus is no longer on the witness's competency, but rather on the witness's credibility. That's not to denigrate the concept that the witness must nonetheless be competent to testify, but more importantly, it's the witness's credibility once they do testify. That's the prime focus. The term competency, as applied to witnesses, refers to the characteristics which render a person legally fit and qualified to give testimony in any proceeding, civil or criminal, or before any person who has authority to receive evidence. In Brown versus State, the court ruled that the fact that a key witness changed his story on other subsequent occasions went to the credibility of the witness and not to the competency of the witness to testify. The court was considering the grant of a new trial to the defendant and the effect of the witness in such a new trial were it to be granted. In that particular case, the witness testified against the defendant, and then after the defendant had been convicted, the witness retracted their in-court testimony and then subsequently restated as truth the testimony that the witness actually gave in the trial. Now we've got the witness saying two different things in court and out of court, and then in the middle, other statements retracting that court testimony. And you can see obviously what happened. The witness testified and then had a change of heart, so recanted on the testimony, and then when they realized that they might be in trouble with the court for perjury charges, they went back to adopting their testimony in court again. But the object of the court's scrutiny was whether, if a new trial were to be granted to the defendant, how would the witness's testimony be received in any event by the jury because of this constant changing the scope and content of the witness's testimony. In order to exclude a witness on the basis of competency, the opponent must rely on other provisions dealing with the testimony of interested persons, such as lack of personal knowledge, which is an extremely important one, and other provisions relating to the disqualification of a witness. 9607 disqualifies a trial judge or jury member from testifying in a case where they served in their official capacity. The presumption of competency, however, does not bar other sanctions. Witnesses convicted of crime, including perjury, atheists, and agnostics, are not disqualified from testifying. These exclusionary tests had been demoted to the grounds for impeaching the credibility of the otherwise competent witness, although that statement may run into some difficulty with respect to charging someone on cross-examination that they're not telling the truth because they are either an agnostic or an atheist. The code has rejected earlier rules that certain types of persons were too unreliable to draw upon as a source of evidentiary information by reason of their status, beliefs, including religious beliefs, or relationships to the cause. The relevant sections of Florida Evidence Code are 90.04, competency of the wife or husband to testify in a case involving the other spouse, 90.05, parties to the action. Of course, at one time, they were barred from testifying under old common law, or those interested except survivors, and that deals with survivor interests. 90.06, atheists may testify by statute, and 90.08, conviction of a crime will not disqualify a witness. 90.611 states that the evidence of the witness's religious beliefs is inadmissible to impeach or enhance testimony, as I said a few moments ago. Florida Statute 914.07 makes a general statement about the competency of evidence as to a witness and says that, except as otherwise provided, the law regarding competency of evidence and witnesses in civil cases shall apply in criminal cases. And that basically applies this competency rule across the board to any type of testimony that's going to be held in a tribunal in Florida. And I touched on it just a moment ago, lack of first-hand knowledge. This issue has been discussed in detail in Module 4. However, it's important to remember that under this requirement, the failure of a non-expert witness to have first-hand knowledge of the facts upon which his testimony is based will, if challenged under Rule 104, result in the witness being disqualified as a witness on the subject. Now, we just talked about the 600 series statutes that talk about the qualification of a witness and the competency of a witness to testify, leaving a broad area there. And these are by definition establishing these issues. Rule 104 is the rule under which the judge actually decides any incompetency of a witness claim. So you'll see those used interchangeably, but they are different. Rule 104 is the rule that gives the judge the authority to make these decisions. The statutes, 600 series of statutes, 601, for example, give the court definitions to apply in that decision-making process. A trial court, as I just said a moment ago, has exclusive responsibility under Rule 104A to determine preliminary questions about whether a person is qualified to be a witness, among other things, of course. Under this rule, the court also makes all evidentiary rulings in terms of admissibility. Nonetheless, that responsibility is largely mooted by Rule 601, which makes all witnesses competent except when state law applies the rule of decision and makes a witness incompetent. The one exception is the requirement that the witness have personal knowledge of the subject matter of the testimony. Again, this is the federal system, and it states that any state witness incompetency issues in a diversity of citizenship case, for example, in federal court, will apply the state rules with regard to witness competency and incompetency. Diversity of citizenship cases are those cases which are filed in federal court under special federal statutory jurisdiction, but the issue is to be decided is governed by state substantive law. Rule 601 at this juncture is a federal substantive law under FRE 601, and it brings in the law of decision with respect to witness incompetency, the state law of decision that controls these substantive issues in the case to apply in federal litigation of a diversity citizenship case. But nonetheless, both agree specifically that in any event, a witness must have personal knowledge of the subject matter of the testimony. Otherwise, the rules discard insanity, infancy, interest in the proceedings, and religious belief as grounds of incompetence. In turn, the question of personal knowledge should be treated under Rule 104B. Now, when I say they discard the concept of insanity and infancy in the proceedings, that doesn't mean that cannot be a grounds for declaring a witness incompetent. Quite the contrary. If it's established that the person has mental or emotional conditions that prevent them from understanding what they're saying or prevent them from properly conveying any information they may have, they can be disqualified. And the same with respect to infancy, that a child too young to understand the oath and or the responsibility to tell the truth and or their ability to communicate might be disqualified as a witness as well. The determination of admissibility under Rule 104A is more demanding than prima facie tests and call for the exercise of a judicial fact-finding responsibility by a trial judge. Responsibilities which require the judge to evaluate both credibility and weight of evidence. In the Enright case, the court opined that focusing on the trial court's obligation to determine a preliminary question, the trial judge reasoned that the rule imposes a greater duty upon the court than simply to satisfy itself that a prima facie case exists. Instead, the district court, as the trier of preliminary questions, again under Rule 104, must resolve by a preponderance of the evidence whether the government has demonstrated the existence of a conspiracy and the defendant's connection with it. That the particular case in question dealt with the testimony of a conspirator as opposed to the testimony of an ordinary witness. The out-of-court statement, otherwise hearsay, of a co-conspirator of the defendant Enright made some statements in furtherance of the conspiracy, which under the hearsay rules is admissible in trial against the person on trial, and that would be Enright in this situation. And the court obviously is addressing what kind of standard and what kind of process the trial court must apply in order to determine whether, in the first instance, a conspiracy actually exists and that both the defendant Enright and this other out-of-court statement witness are in fact involved in the same conspiracy. If the court concludes that they are involved in this conspiracy, then the out-of-court conspirator statement comes in. And if the court concludes that they're not, then that out-of-court statement of the co-conspirator is not admissible. Only when this threshold burden has been met may the district court admit a co-conspirator's out-of-court statement as admissions against the defendant under Rule 802 D2E, one of the hearsay rules. And that's basically the same in state court as well. The compellability of a witness. The American Jurisprudence Second Law Encyclopedia states the public has a right to every person's evidence except for those persons protected by a constitutional, common law, or statutory privilege. The duty to testify is a basic obligation that every citizen owes his or her government upon being properly summoned by a court, and any personal sacrifice involved is a part of the necessary contribution of the individual to the welfare of the public. There is a public obligation to provide evidence, and this obligation persists no matter how financially burdensome it may be, although you'll see circumstances where a court can grant some kind of relief, not financially, but make special arrangements for a witness's appearance, if at all possible. Moreover, the exaction of a citizen's duty to give testimony, whether he or she is properly summoned, sometimes impinges, if not always, upon the First Amendment freedoms of the witness. However, material sacrifice and the invasion of personal privacy are implicit in its performance, and the freedom to choose whether to speak or to be silent disappears, always subject to a testimonial privilege which must be asserted by that witness. The witness simply cannot fail to appear at the appointed date and location. Again, Amjuror instructs that the right of action for damages or for a statutory penalty or forfeiture exists against a witness who, without sufficient excuse, fails or refuses to give oral testimony or to produce documents or other specified items in obedience to the command of a properly issued and served subpoena. This can also, in some cases, be enforced by the proceedings, that is, a contempt of court by the judge, and this is the usual enforcement method in modern court proceedings in both state and federal courts. However, giving false testimony in a judicial proceeding, even though the allegation is made that the person giving the testimony knew it to be false, does not give rise, either at common law or by statute, to a civil action for damages resulting from such testimony, although it might involve and it might result in criminal perjury charges depending upon whether the state attorney elects to do so and depending upon whether the evidence is sufficient to establish a perjury. Witnesses' privileges. These are the kinds of things that a duly summoned witness can nonetheless assert in person in court to relieve him of the responsibility of testifying. And the witness privilege, ladies and gentlemen, is personal to the witness and may be asserted, for example, by any agency or company that has a privilege, which is doubtful. But again, it's personal to the witness. Florida Statute 90.501 states that, except as otherwise provided by this chapter, and that is a chapter on privileges, Section 500 chapter, any other statute or the Constitution of the United States or the state of Florida, no person in a legal proceeding has a privilege to, number one, refuse to be a witness. There are other provisions under this rule that we'll look at in a moment, but it's important to note that the first statement they give is that no person in a legal proceeding has a privilege to refuse to be a witness. And the legislature is clearly stating here that you don't have a privilege not to appear. You must appear. The rule under FRE 501 goes a little bit further, but basically reaches the same result. The common law, as interpreted by United States courts in the light of reason and experience, that's interpretation law, governs a claim of privilege unless any of the following provides otherwise: the United States Constitution, a federal statute, or the rules prescribed by the Supreme Court. But in a civil case, state law governing privilege regarding a claim or a defense for which state law supplies that rule of decision will be applied, because although it's essentially procedural, privileges, when they are established, are held in high regard by the court. I want you to note that the scope of the privileges here are practically the same as in the Florida statute, and the interpretation is going to be basically the same. In discussing the effect of FRE 501 on the issue of federal witness privilege, the United States Supreme Court in Trammell stated, the federal rules of evidence acknowledge the authority of the federal courts to continue the evolutionary development of testimonial privileges in federal criminal trials, governed by the principles of the common law as they may be interpreted in the light of reason and experience. So the federal law does not abolish some of the other privileges that existed in common law. And it's going to be a case-by-case determination by the trial court when these issues are raised under Rule 104 for decision. In rejecting the proposed rules and enacting Rule 501, Congress manifested an affirmative intention not to freeze the law of privilege. In other words, they want it to be flexible. Its purpose, rather, was to provide the courts with the flexibility to develop rules of privilege on a case-by-case basis, which is what I just said. In Tratner, the Seventh Circuit, the United States Court of Appeals, concluded that the obligation is on the person claiming the privilege to present the underlying facts demonstrating the existence of the privilege. It is not enough for an attorney to testify to those conclusions. The responsibility of determining whether the privilege exists rests upon the district judge, which is the trial judge in the federal system, and not upon the lawyer whose client claims the privilege. In other words, the client has to appear and personally claim the privilege and explain why the privilege exists and why the court should uphold the privilege. 501 states that privileges are recognized only as provided, and I also gave you the first part of 501, except as otherwise provided by this chapter, any other statute of the Constitution of the United States or the state of Florida. No person in a legal proceeding has a privilege to, number one, refuse to be a witness, as we stated, refuse to disclose any matter, refuse to produce any object of writing, prevent another from being a witness, from disclosing any matter, or from producing any object or writing. While most rules of evidence in Florida are intended to promote uncovering the truth, privileges are designed to exclude evidence for reasons totally unrelated to this goal. Instead, the privileges seek to protect other interests or relationships. So there's a tension here between the need and the desire to have as much information as possible, and at the same time recognizing that under certain circumstances, information is privileged and should not be disclosed in court for societal reasons. Thus, evidence that may be very useful in the fact-finding process may nevertheless be excluded as privilege. The attorney-client privilege, for example, and the marital communications privilege aim to protect those relationships based on the assumption that it will promote open communication between a lawyer and the client or between spouses. This benefit is deemed to outweigh the cost of excluding otherwise probative evidence. And the Florida Evidence Manual continues and states, once established as applicable, the privilege will apply to all stages of the judicial proceeding. For example, the evidence is not discoverable, so you can assert it under interrogatories or depositions, and it is not admissible in any phase of the process, such as preliminary determinations or grand jury proceedings. Furthermore, to invoke a privilege, there is no requirement that they be parties to the litigation. In fact, only the intended beneficiaries of the privilege have standing to claim or waive it, and that's important. Only the intended beneficiaries of the privilege have standing to claim or waive it. At early common law, only two testimonial privileges were available: the attorney-client privilege and the state's privilege against compelled disclosure of the identity of an informer. Over the years, most legislatures have enacted a variety of privileges and have expanded the doctrine to include communications made within a wide range of relationships. The development of court-made privileges has come to a virtual halt. Consequently, the life of privileges, whether by way of extension or retraction, is now a legislative problem for the foreseeable future. In Florida, for example, Section 90.51 specifically recognizes only those privileges that are provided by Florida statute or by the Florida or the U.S. constitutions. This has the effect of abolishing all common law privileges previously available in the courts in Florida and limits the creation of future privileges to statute or constitutional provision, which would include the Florida Supreme Court's constitutionally mandated rulemaking power. The Florida rules do not address themselves to those constitutional safeguards protecting the criminal defendant against the use of various forms of impermissibly gained evidence. That essentially is not contained in the Florida rules. It's contained in either the Florida state constitution or the United States Constitution. And those guarantees have their own rights and have their own issues, which we'll talk about during the course of this series of lectures. Neither do the Florida rules treat the criminal informant privilege, which remains viable despite the claims of abolition of all other common law privileges. The federal rules of evidence avoided the entire privilege controversy by leaving the matter up to the courts pursuant to common law or to the states. State law of testimonial privilege will be applied, as I said before, in diversity actions and in federal question cases where an issue is governed by state substantive law is the subject of the proffer. Whether or not Erie versus Tompkins, and it's principally applied in diversity of citizenship cases, and I'm not going to go into a discussion of that case because its reasoning is complex. Whether or not the holding in Erie results, it could conform to our notions of comity and federalism and become the federal, and because the federal courts are bound to apply state privilege rules, there is no incentive to engage in forum shopping. And essentially, if there is complete diversity in a case, that is, a plaintiff, for example, resides in Florida and was involved in an automobile accident on I-95 in South Carolina, and one of the drivers was from South Carolina and another driver was from Georgia, the Florida plaintiff may sue either one of these defendants in their own home state, or may sue in the state of South Carolina where the accident occurred in the state courts. Under federal diversity statutes, the plaintiff residing in Florida may bring a suit in United States District Court, the federal courts in Florida, against these other two defendants and require them to appear in federal court. And this is a special statute for jurisdiction. And the requirement is there must be total diversity. In other words, none of the defendants can also reside in Florida. If they do, then the plaintiff has to sue that defendant here and sue all the others here as well. Well, he doesn't have to sue all the others here as well, but he's got to sue that defendant here in state court, not in federal court. So once the case is in federal court, the federal courts are bound to apply state privilege rules. There is no incentive to engage in forum shopping. So the individuals don't attempt to get the best court or the best judge of those series once the case is filed in federal court in Florida. There's no requirement for the plaintiff to try and figure out where they're going to bring suit, because under the example I just gave you, 3 different courts have a jurisdiction. Actually, 4. Florida does as well, but that's a stretch there. And it's a difficult thing to try and figure out if it were not for the diversity of jurisdiction rules. And I will tell you now, this won't be on the exam, so you can relax. Interests protected by privilege. Despite certain dissimilarities in their purpose and effect, all testimonial privileges rest upon a common justification. The protection of certain interests and relationships considered to be of such social importance as to outweigh any competing demands for the production of proof in a given case. The counter-argument, of course, is that any privilege against the compelled disclosure of the information obstructs the administration of justice by denying the tribunal access to crucial facts. And as I said before, that's that constant tension that always exists when a privilege is asserted. The protections afforded by the rules of testimony privilege are neither mandatory nor self-executing. The claim of privilege, as I said before, must be invoked for or on behalf of the privilege holder, and this is the person whose communications will be protected against compelled disclosure and whose interest is fostered by the particular privilege, even if the interest is extrinsic to the trial. In other words, it could be something else. The trial may deal with one issue, and the privilege doesn't really apply to the substantive issues so long as it is material. The privilege will run to stop the requirement that that person will disclose information that's otherwise privileged. If it's not material, obviously it's not going to come in any event. The privilege holder, however, is often a party or a witness in the proceedings where the claim of privilege may be invoked. So the extrinsic interest is a remote situation. The focus upon the privilege holder must not lead to the view that the privilege is designed to protect some purely private interest. The real objection and object of protection is the social and public interest in the confidentiality of communications. The persons protected are only the objects of legal concern as they incidentally may occupy the status or relationship the particular privilege is designed to foster and maintain. For example, when clients are permitted to seal off from courtroom inquiry communications with their lawyers, it is not their personal interests that are being promoted. It is the concept of the attorney-client relationship that's being protected. And the reason for this is obviously quite clear. Because litigation in the courts in the United States, and to a great extent to other courts, at least in the Western civilizations, are so complex that individuals do need the advice of counsel to assist them in negotiating the trial of a case. And without that ability to communicate with your lawyer, cases would be an absolute shamble, and it would simply clog the courts and prevent litigation from proceeding in serious cases. So as a consequence, that's what's being protected by the lawyer-client privilege. Very simple. It's not a personal interest, it's a societal interest in protecting that relationship so that there will be free communication. The reasoning is that our increasingly complex society cannot operate rationally without expert legal advice. Lawyers can act effectively only if their client can disclose all the facts necessary to render such advice. It is assumed that by safeguarding these relations, a client will give a fuller disclosure of the facts to counsel if assured that the information given in confidence will not be extorted later from the lawyer called as a witness. The only outstanding exception to the attorney-client privilege is that communications to the lawyer of plans to commit future crimes are not protected. Any communications with respect to prior crimes both those charged and otherwise, is protected under the attorney-client privilege. In similar fashion, a theoretical basis of society and social necessity underlies every claim of privilege recognized by the law. These claims to social benefits are no less real by being indirect, but in some respects are highly speculative. Clearly, every successful indication of a claim of privilege withholds information from judicial scrutiny and may impede demonstrably the search for truth at trial. All right, let's talk about a specific personal privilege, the privilege against self-incrimination. And it is the first and foremost evidentiary privilege. And I'll discuss it here. Common law privileges, the fundamental basis upon which all rules of evidence must rest, if they are to rest upon reason, is their adoption to the successful development of the truth. And since experience is of all teachers the most dependable, and since experience also is a continuous process, it follows that a rule of evidence at one time thought necessary to the ascertainment of truth should yield to the experience of a succeeding generation whenever that experience has clearly demonstrated the fallacy or the unwisdom of the old rule. And this is a statement by the United States Supreme Court in 1933. I will discuss the privilege against incrimination in another module. And here I've also restated Florida Rule 90.501. The privileges where the Florida legislature have recognized by rule are the journalist privilege, the lawyer-client privilege, fiduciary lawyer, psychotherapist patient, sexual assault counselor victim, domestic violence advocate victim, husband and wife, clergy, accountant client, and trade secrets. Notice there's no specific doctor-patient privilege. However, there are rules of professional conduct which restrain doctors from communicating. And of course, now there is a federal law, the HIPAA law, that says that any health service provider is prohibited from disclosing any information whatsoever regarding a patient unless that patient gives them authority to do so. And that's a federal statute. Privileged communication is necessary to an adverse party. Now, this is an interesting rule. In any civil case or proceeding in which a party claims a privilege as to a communication necessary to an adverse party, the court, upon motion, may dismiss the claim for relief or the affirmative defense to which the privileged testimony would relate. Now, this only applies to a party to the suit who is in possession of material information regarding the case or the defense of any claim that they've made against someone else, but falls within the scope of a privilege so that they claim the privilege not to disclose it, especially if it's information that the opponent needs. And if the privilege applies, the court will recognize the privilege. But under this Florida statute, the court may dismiss any claim for relief if the person has asserted a privilege for information that is necessary or information necessary to an affirmative defense. So this is a very strict rule. In making its determination, the court may engage in an in-camera, that means basically in chambers out of court, inquiry into the privilege. In addition, there is a presumption that exists in Florida law that if a party in control of information otherwise declines to provide that information, typically by discovery, in other words, an individual is sued and on the grounds that they are not qualified to hold an office in Florida under the election law, and on the specific grounds that they are not a United States citizen, which some posts require, then if that person is sued and a subpoena is laid in their hands requesting the production of a certified copy of an original birth certificate, if that person fails to produce that document, then the court may rule that it creates a negative inference in the trial, in that the information which would be contained in that document is not in the best interest and in fact is against the position asserted by the defendant, and basically withholding pertinent information that is indicative of a negative result by a party can be held against them by way of creating an inference that in fact it is negative to them. And a court can make a decision based upon that negative inference and can instruct a jury to do so as well. So that is a serious component of our rules of evidence with respect to communications. And here we're saying privileged communication necessary to an adverse party. That's a limited application of it. But other case law in Florida clearly states what I've just discussed in terms of raising a negative inference, that any information that's being withheld from the court by a party would be negative to that party's position. Serious consequence, and could be pivotal in litigation. Refreshing a witness's memory. Section 90.613. When a witness uses a writing or other item to refresh memory while testifying, an adverse party is entitled to have such writing or other item produced at the hearing, to inspect it, to cross-examine the witness thereon, and to introduce it, or in the case of a writing, to produce those portions which relate to the testimony of the witness in evidence. If it is claimed that the writing contains matters not related to the subject matter of the testimony, the judge shall examine the writing in camera, again in chambers, excise any portions not so related, and then order delivery of the remainder to the party entitled to the document or entitled to see the document. Any portion withheld over objection shall be preserved and made available to the appellate court in the event of an appeal. If a writing or other item is not produced or delivered pursuant to order under this section, the testimony of the witness concerning those matters shall be stricken. And here's another instance where, for example, if a party is on the witness stand and they have a document and exclusive control over a document or the source of that document by way of privilege or otherwise, and they decline to produce it, the testimony of that witness concerning those matters shall be stricken from the record. Then you can see there's another dire consequence that looms here, even in the refreshing the recollection of a witness. The defendant is not entitled to all of the field notes of a state crime analyst under 613 after those notes were used to refresh the analyst's recollection on direct examination, where the trial court determined that the remainder of the notes were not related to the precise subject matter of the witness's testimony. So that has to be in the witness refreshing area in terms of the documents that may be used to refresh a witness's recollection. That has to control by way of court determination that the other contents of the document are not relevant to the proceedings. Consequently, you're not entitled to see those, even though portions of the document not relating to the witness's recollection are present in a document. You can't see the whole document, but the court, in an in-camera review under Rule 90.613, can redact those portions that are not relevant and allow the rest of the document to be viewed by the opponent. And keep in mind that the opponent may use that redacted document in evidence if it's appropriate, but they do have a right to see it in any event. And this, again, is witness recollection. This is a narrow area here. Usually, anything that appropriately causes a witness to recall pertinent facts to a case can be utilized, except, of course, leading questions. So this narrow ruling here actually reflects the ability of the court to redact information before producing the entire document that the witness is using to refresh their recollection. The same statute prohibits either a witness or counsel from publishing a refreshing document's contents to the jury to avoid parading potentially inadmissible evidence before the trier of fact. So that's another narrow approach to the use of a document to refresh a witness's recollection in Florida courts. This allows the proponent of the witness some freedom to use a document to refresh a witness's recollection, because it typically cannot be introduced into evidence to the jury to avoid parading inadmissible evidence. And again, under 613, the court can redact information from the document. So there is another example of the application of that rule. The use of a letter to refresh a witness's recollection was improper where the witness professed no lack of memory. The examining counsel improperly suggested the contents of the letter, and counsel provided an interpretation of the letter's substance in the jury's presence, and that's in that Clausen case. And of course, this is reversible error. So if the witness doesn't say that they don't have a lack of memory, that they don't recall what it is that the lawyer is trying to question them about, if they don't say that they don't remember, you cannot attempt to refresh the witness's recollection, because in this situation, all the examining counsel is doing is asking a momentous leading question, which provides all of the answers to the witness. So that's clearly not proper. The witness must claim that they don't have a recollection before that witness refreshing context comes into existence. Let's talk now for a couple of minutes about an interesting subject: present recollection revived versus past recollection recorded. This is an opinion by the Court of Special Appeals of Maryland in 1977. It was written by Judge Moylan, who happens to be a good friend of mine. At page 597 of that opinion, Judge Moylan says, "It is, of course, Hornbook law that when a party seeks to introduce a record of past recollection, he must establish, one, that the record was made or adopted by the witness at a time when the witness did have a recollection of the event, and two, that the witness can properly and presently vouch for the fact that when the record was made or adopted by him, he knew that it was accurate." Now, this situation is called past recollection recorded. And this is a very narrow use of refreshing a witness's recollection. And basically, it deals with the fact that a witness may be on the witness stand, and because of the passage of time or whatever reason, they don't remember exactly what happened, or they don't remember the substance of the question so that they can effectively answer it. If there is a document in existence, the attorney who is asking the questions of this witness may present the witness with a document that should refresh their recollection. If the witness looks at the document and said, "Well, I see this, but I still don't really remember what happened. It's just still not clear in my recollection," under this particular provision of past recollection recorded, if the attorney asks the witness if the witness recalls making this document or seeing this document being made, and that at the time the document was created, it was true and properly reflected the facts as claimed in the document, then that document can be introduced into evidence because the witness has in effect adopted that document as being true based upon their recollection, even though they can't remember exactly the facts that the document discusses. And this is past recollection recorded, and the document, if it's vouchsafed for by the witness, comes into evidence to prove the facts contained in that document. On the other hand, had the appellant herein sought to offer the police report as a record of past recollection on the part of a police officer, it's elementary that she would have to show that the report had either been prepared by Officer Bolton himself or had been read by him, and that he can now say that at the time he knew it was correct. So he doesn't have to create this document. Someone else can create it, so long as the witness can testify that when the witness actually saw this document, they knew that the information in the document was true. Absent such a showing, the trial judge would be correct in declining to receive it in evidence. When dealing with an instance of past recollection recorded, the reason for the rigorous standards of admissibility is quite clear. Those standards exist to test the competence of the report or the document in question. Since the piece of paper itself, in effect, speaks to the jury, the piece of paper must pass muster in terms of its evidentiary competence. And this footnote to that says, all of the tests for such evidentiary competence for a record of past recollection are fully set out and discussed in Wigmore on Evidence and also in McCormick. And you will see in your accompanying required reading materials McCormick's discussion of past recollection recorded and present recollection revived. The primary difference between the two classifications, present recollection revived, past recollection recorded, is the ability of the witness to testify from present knowledge. Where the witness's memory is revived, he presently recollects the facts and swears to them. He is obviously in a different position from the witness who cannot directly state the facts from present memory after an attempt to revive his memory, and who must ask the court to accept a writing for the truth of its contents because he's willing to swear for one reason or another that its contents are true. So again, that's the primary distinction. In one instance, the document is used when a witness claims they can't remember what happened. The document is used in an attempt to refresh the witness's recollection as to what occurred. And that can be anything, for that matter. It can be a police report, even if he didn't see the police report earlier, even to say that it was true or not, or any other kind of a document which contains facts that the witness was aware of at the time but have forgotten. That document presented to the witness can refresh their recollection, and if they say, oh yeah, now I remember what happened, that document doesn't come into evidence. The witness themselves now, with their present recollection revived, testifies as to the facts, and they're subject to cross-examination on that issue. But if that doesn't occur, and if the witness' recollection is not revived, the document itself may be admitted into evidence if the witness can look at it and say, well, I do remember seeing this document earlier on, and when I saw the document, I knew that the facts contained in it and described in it were true. And this document can be created by anybody, for example, a police officer, or another witness statement, for example, some other eyewitness, or the document could be prepared by the witness that's testifying. In any event, by saying that when I saw this document, I knew the contents were true, the witness has adopted under oath the contents of that document as though it were his own testimony. And it is the provenance of that document that's usually subject to some kind of cross-examination. But the document comes into evidence to prove the facts that are contained in it, because the witness has adopted them as his own testimony. It's one thing to awaken a slumbering recollection of an event, but quite another to use a memorandum of recollection, fresh when it was correctly recorded, but presently beyond the power of the witness, so to restore it that it will exist apart from the record. And here's an explanation basically of what I just said. The difference between present recollection revived and past recollection recorded has a demonstrable effect upon the method of proof. In the instance of past recollection recorded, the witness, by hypothesis, has no present recollection of the matter contained in the writing. This is after an attempt to refresh the recollection of the document has been made. Whether the record is directly admitted into evidence or indirectly by the permissive parroting of the witness, it is nevertheless a substitute for his memory and is offered for the truth of its consequences. It assumes a distinct significance as an independent probative force and is therefore ordinarily required to meet certain standards. Witness self-incrimination. Confessions and admissibility and voluntariness. It's a fundamental rule of law in American jurisprudence that in order for a defendant's confession statement or admission, either verbal or written, to be received into evidence or even considered in any way, that confession statement or admission must be shown to be voluntary. And that's the threshold question. We can forget about Miranda, we forget about all the other coercion that in general would vitiate a confession. If the statement's not voluntary and is in fact the result of coercion or threats or violence or any other inducements that cause the person to make the confession, then it's deemed to be involuntary and is inadmissible on its face. And this is especially so if the evidence challenged by the defendant. And this concept, of course, is embedded and embodied in the Fifth Amendment to the U.S. Constitution. So it is this voluntariness issue that is overall and superintending, and that the Fifth Amendment will superintend. The voluntariness rule was originally designed to prohibit the use of torture to extract a confession. In earlier times, persons were put on the rack or the soles of their feet were burned, for example, in order to force a damaging statement from the individual. There was and still is no way for any judge or jury to determine whether the statement is the truth or is the result of the individual simply telling their captors what they wanted to hear in order to avoid any further torture. Thus, the voluntariness rule was brought into play as an automatic rule of exclusion if there was any evidence of torture. This rule goes much further in its application. Consider for a moment what might force you to give a false confession. Suppose that you were told that your children, your spouse, your mother, father, or anyone else in your extended family, even your pets, will be painfully tortured, maimed, or even killed if you don't confess to a crime that you didn't commit. This is serious psychological torture, which calls into question the voluntariness of your, quote, confession. What would be your reaction to a threat to publish compromising photographs of you or reveal an indiscretion such as adultery, which your spouse doesn't know about? All of these can be considered to be psychological coercion, and any statements that are taken as a result of this kind of pressure will result in the confession not being received into evidence if the trial judge is convinced that that's what happened. And needless to say, if somehow or other the confession gets past the trial judge's scrutiny, the defendant can certainly also testify or establish with other witnesses, if possible, the situation which resulted in the production of this so-called involuntary confession, and let the jury decide whether they should give any credibility to it whatsoever. Because at that point, the confession is just a piece of evidence that can be challenged on cross-examination or can be challenged in the defendant's case as to his voluntariness. And that becomes a question of fact for the jury to decide if the judge has already let it in. In essence, any form of undue pressure will result in a confession being excluded from evidence. Because of questionable practices, the U.S. Supreme Court decided to create a prophylactic evidentiary rule which must be followed affirmatively and shown to have been followed in every instance where the prosecution offers the confession of an individual as evidence against them. And that is the essence of the Supreme Court's decision in Miranda versus Arizona, which resulted in the Miranda warnings, or the Miranda rights as they are commonly known. And I will discuss this in great detail in Module 11 when we talk about confessions and the Fifth Amendment privilege. And as you will see when we discuss this in Module 11, there are exceptions with respect to the admissibility of confessions that have been engrafted into the process by the U.S. Supreme Court. They'll be discussed, as I said, extensively in Module 11. Once again, I thank you very much for your patience and your careful attention.